Ini setting sini, kita tengok kat general. Kat general tengok. Sekejap, ada tak? Aku ni pakai lama pun tak teringat juga. So kita jarang pakai.
The respected Dean of the Faculty of Law, Universitas Bengkulu, along with all members of the faculty leadership, the respected distinguished speaker, both present in this hall and joining us online, the respected lecturers of the Faculty of Law, Universitas Bengkulu, our distinguished guests, both in person and online, esteemed participants, both offline and online. Ladies and gentlemen, it is my great pleasure to welcome you all to the international conference entitled AI, Indigenous Knowledge and Green Patents, Rethink Justice in International Intellectual Property Law. My name is Hafiza Zia, and I am honored to be your master of ceremony for today's seminar. To begin our seminar, may I kindly invite all distinguished guests, speakers, and participants present in this hall to rise for the singing of the Indonesian National Anthem, Indonesia Raya. For those joining us online, we kindly invite you stand wherever you are. Please be stand. Ladies and gentlemen, we will now proceed to the prayer which will be led by Mr. M. Ilham Adepio SHMH. To Mr. Adepio, the floor is yours.
Ladies and gentlemen, before we begin this international seminar, let us take a moment to pray to Allah that this event will be blessed and beneficial for us all. With your permission, I will lead the prayer according to Islamic tradition. A'udzu billahi minasyaitonir rajim. Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin. Sayyidina wa maulana Muhammadin wa ala alihi wa sahbihi ajmain. Ya Allah, Ya Rahman, today we gather for the holding of the international seminar with the theme AI, Indigenous Knowledge and Green Patents, Rethink Justice in International Intellectual Property Law, organized by Master of Laws Program, Faculty of Law, Universitas Bengkulu. Make this occasion a beneficial assembly of knowledge that broadens our scholarly insight, particularly in understanding the intersection of technology, the wisdom of indigenous peoples, environmental and sustainability, and justice in the global intellectual property system, strengthens the bonds of our international academic brotherhood, produces meaningful contributions for the common good, and serves as a driving force for the progress of the nation, as well as the well-being of this world and the hereafter. Ya Allah, Ya Karim, grant us beneficial knowledge and give us ease of understanding throughout this event, so that all of us who are present may become people of noble character and intellectual excellence. May the discussions on artificial intelligence, the protection of indigenous knowledge, and green patents inspire us to uphold justice, defend the rights of the marginalized, and contribute to a more equitable and sustainable world. Make the knowledge we gain a provision for practicing righteous deeds and for producing scholarly works that benefit others. ربنا تقبل منا دعاءنا ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار والحمد لله رب العالمين. والسلام عليكم ورحمة الله وبركاته.
Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera untuk kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan. I stand here for deliberate opening speak on behalf of the Rector University of Bengkulu, because this morning the Rector cannot join us because there are other activity at the same time. Assalamualaikum warahmatullahi wabarakatuh. Yes. A very good morning to all distinguished guests. Honorable Dean of the Faculty of Law, respected speakers and scholars from various countries, esteemed academics, students, and participants. It is a great honor for me to join this prestigious international conference organized by the Faculty of Law Master Program, University of Bengkulu. First of all, I would like to express my highest appreciation to the Faculty of Law for initiating this remarkable academic forum and for successfully bringing together distinguished experts from Indonesia and abroad. This conference clearly demonstrates our shared commitment to strengthening international academic cooperation and advancing legal scholarship in response to contemporary global challenges, the theme of today's conference. The theme of today's conference, AI, Indigenous Knowledge, and Green Patents, rethinking justice in international intellectual property law, in both timely and highly significant. We are living in an era where technological transformation, environmental sustainability, and social justice interest in increasing complex way. Artificial intelligence is reshaping innovation, indigenous knowledge system demand, stronger legal recognition and protection, and green technology are becoming central to the global sustainability agenda. These developments required legal institutions and scholars to rethink how justice can be embedded within international intellectual property governance. As a university, the University of Bengkulu strongly believes that higher education institutions must play an active role in generating critical ideas, fostering interdisciplinary dialogue, and building international networks that contribute to global solutions. Through events like this, we reaffirm our commitment to academic excellence, impactful research, and meaningful global engagement. I sincerely hope that this conference will serve as a productive platform for exchanging ideas, developing collaborating research, and generating policy-oriented legal insight that can contribute not only to academic discourse, but also to broader social progress. To all speakers and participants, thanks for your valuable presence and contribution. Your participation strengthens the spirit of international partnership and scholarly innovation that we deeply value. By saying Bismillahirrahmanirrahim, the International Conference of the Faculty of Law, University Bengkulu, is officially opened. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
May I kindly invite the Dean of the Faculty of Law, Universitas Bengkulu, to present the token of appreciation following the Miss Key and the all lecturers to now we will now proceed to a photo session. So you can, may I invite all speakers, distinguished guests present, and the lecturers in the venue to come forward, and all participants in the room to kindly stand to take a photo session. Terakhir. And all participants in the room to kindly stand, please. Ladies and gentlemen, We will now proceed to the main session of today's seminar. It is my great pleasure to introduce our moderator, the respected Dr. Emma Septaria, SHMH. Please give a warm round of applause, both in the room and virtually, to our moderator, Dr. Emma Septaria, SHMH. The floor is yours.
Check. If there is no protest, I will assume that I am audible, right? So, Assalamualaikum warahmatullahi wabarakatuh, and good morning, good afternoon, good evening for everyone in this room and in the Zoom room and also in the YouTube channel and wherever in whichever part of the world you are now. Ibu Zia, thank you very much, the sweetest MC ever. And thank you for Honorable Dean for the inspiring opening remarks and for officially opening this international conference. So distinguished speakers, respected colleagues, ladies and gentlemen, my name is Emma Septaria, and it is a great pleasure for me to serve as your moderator for today's academic session. Before we begin, allow me to say that today's topic is not only academically important, but also extremely in and timely. Why? Because AI is no longer a future issue, right? AI is there, a part of our classroom, our research, our legal drafting, even perhaps the way some of our students write their assignments. Agree? And so yes, AI is everywhere, and sometimes it's even faster than our legal reforms itself. And what makes this theme special, compelling, is the intersection. So the intersection international intellectual property law. This is why today's discussion is both intellectually urgent and globally relevant. And before I proceed, allow me to briefly explain the flow of our today's session. First of all, each distinguished speaker will have 20 minutes. Let's see. 15 to 20 minutes actually for presentation, followed by the discussion and also question and answer session after all presentations. And also, I'd like to kindly inform all of the participants that one of our speaker, Dr. Husham, is unfortunately unable to join us today because unforeseen regional circumstances and his temporary relocation for safety reasons. Yeah, the war like there. And we sincerely send our best wishes for his safety and well-being. And we hope to welcome him in the future academic collaborations. So it is now my pleasure to invite our first speaker, Ms. Ki Narumol Tanisro. Please welcome. Using on ownership uncertainty, Thai legislation, and comparative legal responses to AI-generated works. So, Ms. Narumol, the floor is yours. And you are free whether you want to see here or you want to wander here, there, and everywhere. Okay. And I'm going to time you. I'm going to remind you. On the 80 minutes, I'm going to like ask you to
Okay.
summarize. Okay.
All right.
Yeah.
Actually, I got a presentation as
Yes,
well.
yes. The presentation slides.
Yes.
Yeah.
Okay. Today, it looked beautiful, right? Because I used some of AI to generate this work that comply with my topic. All right. Today, I'm going to. Can I stand? Yes. All right. Back to be a lecturer. Okay, I'm going to talk about, let me introduce myself first. My name is Narumon Tanitsalo. I'm come from Thaksin University Faculty of Law. That today is my topic. We're talking about the artificial intelligence, or we call AI, right? And it's correspond with the intellectual property right protection. I will focus on copyright, which seems to be close to us. Okay, next please. Okay, first of all, we have to know what AI is. AI, it's how is evolution. AI is come from the massive of information, right? It come from what information from? It's come from human, right? As you know, we do the information and provide in various sources, like in internet. You can search in Google, you can find that. Then, when you put some question, right? When you put some question like you would like AI to answer you, AI will process. You know, they will process information to the meaningful and responsive output. You can get the answer, right? That's why in nowadays, people in Thai, the survey can show like it use AI like for 17% from 2014, increased to be 24% in 2025. It showed that AI can help you to work. You know, even it can replace you in some human skill. Okay, next please. Then more than it can replace you in some skill, it can create more. We talk about the AI capacity. In nowadays, AI even can make a work same as us, you know? Even you can put some things. You, like same as my student in just this semester, we find a new like legal topic to do a research. So you can put ask for the AI, right? What is interesting topic legal in nowadays? They can get answer for you. Even more than that, you get the answer, right? You will get the concept paper from them as well. Yes, that's why we come to another one. Even AI can even create a work, can create even a literature like us, you know? It can come like, shall it protected? You mean like can works created by AI qualifies for the intellectual property protection? It mean like the work that create from AI can get protected at the copyright work. Yeah, but the problem is come to the our topic about the legal. You know, in nowadays, even the copyright works is based on human work. It mean like the work will be protected if it come from human, right? But okay, next please. Like for same as in my country, in Thailand, we have the Copyright Act 2565 2022. It's my present law that relevant to AI. But in that act have nothing to talk about AI, with effects to be some disadvantage like for the business or even the AI developer. It's mean like even you create a new work, but you do not have protected. Then you create someone with nothing. So that's why everyone want to create an AI works or even AI model. Okay, then, but this one, from what we talked before, we come to two significant points. Firstly, we're talking about the eligibility for protection. It's mean like the work that created by AI can be protected. Actually, we have three levels of work that can create by AI. Firstly, it means AI create all. You just ask something, can you draw my picture? Boom, like this. You see, same as mine. I put actually, I have to give you some information. My university pays some money for AI model for the lecturer in our university that can use us to work something like this. We can ask them, I put all of my content and ask AI to create the picture that's suitable for this presentation. That's why I use this one. See? Okay, firstly, it's me like AI create all things for you. That's one it seems like you don't have any capacity to join them, right? Secondly, we go to like, if we use AI, but the people it start the work, it's mean like you put AI, you put something that you really want, and then AI create your work. Or in the secondly, the second one is supposed to be correspond with a lecturer or people same as us, like we start the work, we are the man who work that work, but you use AI to support, like for you use AI to check your grammar, right? You use AI to check your spelling, or even you ask AI to improve your work to be more academic, like we do. In our country in nowadays, we always use AI as a supportive tool to get your work is more effective. So we come like for this type of work. So it means and asks about the ownership, like for do we get protected? Because as I told you before, right? Because in Thai law in nowadays, there is no clear relation the issue about that. Okay, next please. So I will show you like in some country that accept or recognize the AI's work. Firstly, in United Kingdom, as one they have the law that is the Copyright Designs and Patent Act 1988. This country, they recognize the rights of program computer. Actually, it's same as my country, but the UK apply AI works as one of the program computer. That's why the people who contribute, like for viewers who developer or even the company, will get the ownership of that one. That's and move to the China and United States. Two of that, it's still based on human. It means like you're gonna get copyright. It means it have to be the grant protection to work with significant human involvement. It's mean like human supposed to be the one or the man who start the idea, who get the capacity, to take the budget, to have the many things on that work to create a new one. Because I think like for the China and United States supposed to be a very good model for Thai as well, because like they still based on human, so that's why the work supposed to start from the human being. Okay, next please. After we get the point of ownership, the thing that very important one is about infringement, because of like for the copyright law, they protect the owner from the exclusive right. It's mean like you have a right to do anything with your work. But as I told you before, right, AI will be more intelligent if it trains, So it's come the problem like how to train the AI. It's same how to train the dragon, like. So it's nowadays we talk about how to train the AI. Same as that, AI have to be trained to be more intelligent. Like for the developer or the old company owner have to put the new massive content, the new massive information on there. With it always usually contain the copyright material. So in the United States, they have a case that why, like for some newspaper company in the New York, they have a failed this. They sue the AI company like Microsoft Word or AI Open that use their material without the permission. So, and remember that the decision of this case, it means like for the AI company have to compensate in some that they use the content without authorized. So the one things we about, if you are a company that file up, you have to compensate when you use other material, But for us, I know for us or even the student in our, I can give you some example because the semester in my country, it just stopped the second semester, so that's like marking or something. We got one exam that to be a describe something about law. So my student is get intelligent than that. They put our clue on the AI like ChatGPT something, right? They provide the answer, so they remember that answer and answer my question. But the question is not correspond that the thing that we have taught them. So that's why he get a very low point. It's me like in nowadays, even you can use the AI, but in some point, AI is not more intelligent than us as well. You know, when you got the information, it's better for you to analyze this again. It's me like when you use the AI information, you know, you got something, ask them, they put your answer. It's me like, it's supposed to contain some copyright material. So it's me like, do we have to take responsibility on that work as well? Because in nowadays, even in Thai, they still have no answer. They still add no answer, but it is quite bad, you know, it's quite bad for the owner of copyright work that AI generates to you and you use that without any permission. So it's supposed to be a next issue that gonna be happen in Thai as well when you use other answer that's come from the AI. I got another example. Yesterday, when I came from Jakarta, I came from KL, I sit next to one doctor from Jakarta. She told me like she is a doctor, like emergency doctor in some in some hospital in Jakarta. She only the expert on like the snake bite. She create the application. Yeah, she create application like such application have the copyright, you know, like for came out at the computer program, but she told me like she applied the AI generate to her app as well. She have like she opened the app to me and show like for first of all, when like someone to get a bite by snake, they will type something, doctor, snake bite or something, blah blah blah. So for the first thing that the app reply you from AI, AI will tell you like what's supposed to be the primary aid. Yeah, she told me like she applied AI and then for the step or something. But actually, it's me like she apply the information that get from AI generate. It might support content to copyright material. So it might come for the future, like for it, she have to take responsibility for the detail or something. Yeah, she told me like for even for her work, you know, he worked in the hospital, like for emergency, she told me like sometimes she use AI as well to act like for what, you know, what identification right now, what support symptom to be or something. Yeah, it's good, a very good topic for you as well. Okay, then the last PowerPoint for me, this one, the South Korea, it's the one country in Southeast Asia or something that they just promote the new X. It's called Artificial Intelligence Basic X, or we call AI Basic X on 20 and 26. This very good, you know, because this law, it concerned about the effects that's supposed to be the business. So they concern your business grow without for the use AI too much. You know, in nowadays, we normally use AI too much, which seem to be good in some time. You get it easy, you know, you get it easy, or even you got some effective answer, but in some, you still infringe other copyright work as well. Yeah, that's all my presentation. Thank you for your
Yeah.
attention.
Thank you very much.
I will come back. I will come back to you.
Yeah. And very kind of you. I don't have to remind you.
It's nearly.
Nearly, yeah. Practice makes perfect.
Yes.
Yeah. Thank you very much, Ajahn Ki.
Thank you.
So now let's move to our second distinguished speaker. She is Professor Dr. Nazura Abdul Manap from Faculty of Law, University Kebangsaan Malaysia. And Professor Nazura is a leading authority in information technology law and intellectual property law with more than 30 years of academic and policy experience, including service as former dean and WIPO expert consultant. And her presentation, Artificial Intelligence and Intellectual Property, the Challenges, address human-centric IP doctrines, training data dispute, deep fakes, also output uncertainty and regulatory reforms. And Professor Nazura, please, time is yours.
Dr. Emma. I've been in touch with you in WhatsApp. Luckily today I can see you in person, although it is online. Okay. I hope my voice is uh, can be heard. It's audible to all
Yes,
of
it
the
is very clear,
yeah. Thank you very
Professor.
much.
Yeah, it's
Okay.
audible.
Okay, then as you mentioned, yeah, I was actually requested, yeah, to share something about is either or the topics given to us, the presenters, and I choose to do artificial intelligence because this topic, as you mentioned in my background, was very, very dear to my heart. Yeah, I am also doing something about the traditional knowledge and traditional cultural expression or heritage as well. But I think for this purpose, and I think it's really timing because as being mentioned by the previous speakers, yeah, Miss Narumo, she has actually set the very nice introduction for the one that I am going to discuss with all of you today, which is the artificial intelligence and intellectual property, and what are the challenges faced, yeah, by us, especially in IP fraternity, right? So just a bit on the objective of my sharing today is I know that the most of the participants are from the magister students, which is S2 students or S3 students here. And I hope that with the sharing here, the students will be provided with comprehensive understanding on what are actually the challenges, how artificial intelligence, being actually carried out nowadays, and how it actually gives, I would say that challenges to the traditional intellectual property law. Right. So actually there are many challenges, but I have actually clusterized it into four, which is one is as mentioned by the previous speakers here about the issues of authorship and ownership. It looks that the law that we have is more of human-centric law. So we don't have laws that actually governing robot yet, especially in Malaysia, yeah, and I suppose in Indonesia and most of the countries in the world. And second one would be what are the issues relating to the training of data, the data training, which is actually related to the input, yeah, input data input disputes. The third one would be the output, yeah, the output from the training of the data when you prompt, yeah, what are the issues or challenges that faced by the laws, and of course, last but not least, is the enforcements and how to balance, yeah, the needs for the enforcement of law and also the need for the rapid development of technology itself. Okay, so now we go to the first one, human-centric laws. Yeah, human-centric laws, as I mentioned, is actually the traditional IP laws was designed, yeah, with in in our mind is to design for the purpose of human creators or inventors, yeah. um but then AI system has actually changed it. It has complicated this principal idea, which actually based on human, whereby the AI now is capable of generating, for example, text, things that we are doing every day, as mentioned by Miss Noromo just now. She can actually use AI to do the presentation. The students can actually benefit AI to answer questions. Yeah, so it actually has complicated the everyday, the daily activities that we normally do. Yeah? For example, they can generate text, images, music, inventions, even without or with very minimal human input. Okay, that is the challenge that will be faced by or has been faced by traditional IP laws. And the next issue would be who owns the output. As also mentioned just now, yeah, is it the programmer? Because AI normally will be based on certain program as ChatGPT by OpenAI. Yeah? So those are the things that being the basis of the usage of the AI. Or is it the user, us, yeah, that is subscribing the ChatGPT or the Gemini, yeah, or the company that trained the AI, or no one at all? So those are the questions that being have been questioning, yeah, by people in the legal fraternity. So now, I have been asking this since I think ages ago. Who owns AI generated work? Yeah, because previously we also, even without the AI that we know now, which is known as artificial intelligence, we already had I would say that the technology then can process data by themselves with very minimal human intervention. For example, last time we have like weather forecast. We have a machine of weather forecast with very minimal human intervention, and the machine will will produce the report of weather forecast. So who owns actually the report of the weather forecast? That was the question that I have been asking before. But when with the emergence of AI generated work, these questions is becoming more important. As for example, under copyright, it's stated there in most of the law in the world, human author, uh, they said that human is the only author of the work, meaning that there is no machine, there is no collaboration with human and machine. As mentioned, the case of Zaria of the Dawn, this is relating to the comic book, whereby in that case the court decided that the text which is produced by the human was protected, but the AI made images that used in the comic was not protected. Yeah, in UK, they said that if no human author is identifiable, so the person who set up the process is considered as author. So meaning that they still need human as the author. And then Malaysia, of course, we are only recognize human as the author of the work, whereby in patent, US, UK, Europe, Australia, Malaysia, I would say that Thailand or Indonesia, they required, or condition that inventor must be a person. If although in the case of Dabus in Australia, I would say the first instance case, they decided that Dabus, who is the AI program, can actually own the patented product. But later on, in the more higher case, they said the more higher courts, they said that no, they can, human being must be the author of the Dabus invention. Okay, the second one would be input. So this input is actually the data being used by the producer of AI program during training or prompting. So here they involve actually many of copyright works. For example, AI models are trained from massive data sets. Includes copyright works, books, images, music, or code. And then, of course, when you use other person's work, other person's copyright work, it may amount to infringement of copyright. Apart from there, even though, for example, if it is not the copyright infringement or copyright infringement in terms of economic works, but moral rights can also be infringed by the person who used he used data to train. He used data belonging to other persons to train the AI. All right. Then can you use copyrighted works to train AI? Let's look at the position in many countries in the world. US says that in the big lawsuits, for example, New York Times and Microsoft OpenAI, Anderson, and Stability AI, it states that if training AI on books, music, art is infringement. So they are saying that whether you cannot just use other people's work without getting permission. In Europe, under the text and data mining rule, allows training unless creators opt out, meaning that they said that, okay, you can use it for for certain purposes unless the creator wanted saying that, oh, you cannot use unless you get license for us. Now, but then Japan and Singapore more flexible. They train for Japan and Singapore, it is more of if you have legal access, meaning that you are the lawful users of the certain copyright work, then you may use it. Yeah. But you do not use the work for direct enjoyment. Yeah, it must otherwise you need to have a special license for that. But Malaysia, unfortunately, we don't have a rule yet relating to these things. Yeah, in copyright, but we are actually in the midst of looking into the provisions and to amend accordingly. And then the third one, output data uncertainty. Output is something, the data that comes out from the AI, meaning that you prompt and you generate content from your prompt. Yeah. These also the same issues as mentioned by the previous presenter, the issues of authorship and ownership. Most of the current laws in Malaysia and other countries in the world saying that a human can only own IP. Because why? Because let's say, for example, in copyright, we need sufficient effort or human intellectual creation to support the existence of originality. Yeah. And then if there meaning that if if there is no human touch or human intervention or human outputs in the making of the work using AI, there is a risk for not being protected, as happened in the US in the case of Zaria just now. Yeah, and then perhaps issues of infringement can be happen. The outputs, for example, can actually be taken from other people's work. Yeah, then as I mentioned previously, it can amount to infringement of copyright. So here the questions comes in: if AI outputs infringe existing IP, who is liable? Is it the developer? Is it the user or AI company? So those questions are actually still in the form of questions. Yeah. And when AI outputs will cause problem. For example, when they have, because last time if you copy a person's work, it must be the in copyright, you must have a substantial similarities. But with the AI the technology, yeah, the substantial similarity has actually changed into something that is not really substantial, but actually you substantially copy it. For example, you copy style or likeness. Yeah. Let's say you have Leonardo da Vinci's portrait, yeah, or a picture or drawings. So you can ask the AI, yeah, to actually copy that particular styles, but with the helps of your prompts. Yeah, you prompts, we want to do whatever. Yeah. Okay, and another question is deepfakes. This always happen even during this war. Yeah, so many deepfakes videos on the social media. So deepfakes also is actually AI produced. Yeah. For example, for European Union, they have a certain act, EU AI Act, requires clear labeling of AI generated or altered content. Elvis Act in US, for example, protects a person's voice and likeness from being cloned without consent. So they have laws governing these issues here. And Denmark now has become, I would say that new provisions in the copyright, they gives people rights over their image, voice, and likeness in deepfakes. So meaning that if you are in Denmark, if you want to use other people's voices, for example, or you want to copy other people's voices or the people's drawings, yeah, style, it's a just style, you have to get permission just like other copyrights work. Okay, now we come to the last one, which is the enforcement. Yeah, enforcement and balance. How are we going to enforce the law on the issues of, for example, infringement of copyright or patent, but at the same time balance the needs to have a high standard or very good technology development. Yeah, so here courts actually having problem, yeah, to determine whether training AI on copyright works without permission constitute infringement. This actually supported in the case of Getty Images and Stability and also NYT and OpenAI. So they are actually, have to decide which one, whether it goes for the owner of AI program or the users, for example. EU AI Act introduced transparency obligations. You have to label AI generated content for your copyright generated work. The US Copyright Office now requires disclosure of AI involvement. But then in Malaysia, both Copyright and Patents Act, we do not yet deal directly with AI. So enforcing IP rights strongly enough to protect creators, but we have to be flexible to give AI developers legal certainty and room to innovate. So what to do? Potential government regulation. Um, we can require, for example, transparency about data, which has been done by US, or make licensing deals for large amount of data easier. Keep inventorship human only. Of course, otherwise human will be extinct because all done by the robot or by the AI. Yeah. And then protect people's voices and likeness from being copied by AI. I think that is a time for us to look into that issues as well. So a little bit on shifted IP value. Now the big money in IP is moving from the book song to, for example, the finished works to data set, models, licenses. So for example, OpenAI, Media's company, News Corporation, EPFT, to use their content for training, Shutterstock made over US 100 million. So meaning that now it's not only the work, the output work, but also they use the AI work. So meaning that they have what they call as something that is not only for the end work, but also apart from that, you can actually license to get AI producer to use it. Okay. What to prepare for creators? They have to record how they do the works. For AI developers to get proper license, document your data sources, and for the government to consider to create a clear rule. Say, for example, tax and data mining rules with published guidelines, yeah, and also other issues that is relating to the challenges that I have mentioned. So I think that's about it, Dr. Emma. I pass.
Your explanation. So, yeah, very inspiring. Now, we have to move to our third distinguished speaker. He is Professor Dr. Chandra Irawan from Faculty of Law, University of Bengkulu. And he is one of Indonesia's distinguished scholar in civil, economic, and intellectual property law with extensive academic leadership experience, including serving as Vice Rector for Students Affairs of the University of Bengkulu. And he is also an internationally published scholar and reviewer for Journal of World Intellectual Property, UK. And his research has made significant contribution to traditional knowledge protection, geographical indication, and communal intellectual property. So today he will be presenting intellectual property for the common prosperity, consistency in the application of the public interest doctrine for human welfare. And this presentation is particularly important because it places intellectual property law within broader concerns of public welfare, equitable access, developing country interests, TRIPS flexibilities, and the protection of traditional knowledge and the genetic resources. And Professor Chandra, the floor is yours, please. You're still mute? Yeah. You are still mute, Professor Chandra. Could you please unmute?
Okay, thank you. The excellent moderator, Dr. Emma Septariana. Luar biasa, kata orang Bengkulu ya. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. It's a pleasure to meet you on this forum. I hope you are all healthy and having a wonderful day. My dear Dean of the Faculty of Law, Dr. M. Yamani, and all Vice Dean in the Faculty of Law, heads of department, uh, heads of study program, and the invite speaker, Dr. Hussam Said Alawasi from Gulf University. He is currently unable to join us due to the unfavorable situation there. And we pray that Jing will soon be back to normal, safe and peaceful. Miss Hong Nung Pam from Hanoi Law University, Professor Dr. Nazura binti Abdul Manaf from University Kebangsaan Malaysia, and Narumal Tanisro from Taksin University. Welcome to the Faculty of Law, University of Bengkulu. All of lecturer and student, educational staff, and everyone present at this international conference at the Gedung Layanan Terpadu di University of Bengkulu, and all of you online participants. I am very happy to be present at this forum, meeting all of you, and I believe in this forum I will enhance my knowledge and understanding of intellectual property law better. I would like to apologize. I should be here with you all right now, greeting you face to face, offline meeting in the GLT building in campus. But that was not possible, and I could only meet you by online meeting using the Zoom meeting platform. Even that it was using online by Zoom, I hope in this international conference can proceed smoothly and successfully. Ladies and gentlemen, today we will discuss one of the most important instruments in the modern economic era, intellectual property and its issues. While the previous two speakers talking about EI and intellectual property. It is very interesting, and I choose a different topic. Perhaps this relate to the implementation of IVR and global human well-being. You see, nothing is more important than useful intellectual work that suffered the achievement of global human well-being. We understand that intellectual property is not just about legal protection for creator, innovator, maker, or designer, which has a more individual or personal dimension. More importantly, it is about how intellectual property must balance private interest with the public interest. Because if there is no balance between the two interests, intellectual property will become as a tool for developed country or multinational corporation to pressure and dictate to developing country according their own interests. And on the other side, we must also look at that intellectual property should function better, be more beneficial, and provide justice for the common prosperity. It seems that this great hope is still very far from being realized. It will likely require a long struggle and prayer to the God for everything to become easier. Of course, it will require a strong struggle to make this happen. It's required extraordinary struggle. It's not easy. And I think all of you agree what I just said. Ladies and gentlemen, there are several basic principles governing international IP regulation that have been adopted into the national law of each country. Once, exclusive right granted by the state to individual or group over their intellectual work. Therefore, only the state has the authority to grant intellectual property right, despite its international dimension. IP is subject to the national law of each country. And the second, legal protection and economic reward for creator, innovator, inventor, designer, breeder. Yeah, the state provide legal protection, allows intellectual property owner to use it recover the capital invested, time, cost, and resources to support the creation of intellectual right. And the second, the right to economically enjoy the fruit of intellectual creativity without interference from other. This is a private right. Intellectual property owner granted limited monopoly right in accordance with applicable regulation. For example, patent protection lasts for 20 years, simple patent for 10 years, and trademark right for 10 years with extension possible. And then intellectual property right must not conflict with morality, religion, or the public interest. As a product of human intellect, intellectual work should uphold moral principle in accordance with the norm of 16 religion worldwide. Furthermore, the public interest should not be sacrificed for the personal interest of intellectual property owner. This is way from the initial concept of intellectual property from Italy, United Kingdom, and France up to the WTO TRIP agreement era. Next slide. This global issue, which are the subject of debate in international forum, both at WIFO forum, at the WTO forum, include access to essential medicine is open, a such story of the relationship between intellectual property protection, particularly patent and the human right to health. In many developing countries, patent medicine are prohibitively expensive, making them unaffordable for developing or underdeveloped countries. For me, this condition is very sad. Intellectual property rights are applied in a very exploitative way and without respect for human life. There are several countries that have received bad treatment from developed country and the large pharmaceutical companies, multinational companies. For example, South Africa experienced this in early 2000 years when the country was facing the HIV/AIDS pandemic. Patented antiretroviral drugs were expensive, around very expensive. When the South African government wanted to pass legislation allowing the import of generic drug, for implementing the doctrine of parallel import, 39 pharmaceutical companies will allow suit against the South African government. This is not good condition. And the second, India, we know India is the state, the world's largest producer of generic drug. Doesn't recognize product patent, but only protection about process patent. This allow local company to produce patented drug and sell them at affordable price. However, after India joining the WTO and trade agreement, India was required to implement product patent and protect drug patent from other countries. What's happened? The drug price in India become expensive. And then Brazil experienced in 2007 through a strategy of negotiating and obtaining a compulsory license from the ACE drug efavirenz with mask from German or US, resulted in Brazil issuing a compulsory license for the drug, wiping the patent in favor of importing a generic version from India at 60% lower price. This was done to save the free treatment program for 100,000 of citizens. And Indonesian have also experienced a similar situation with Brazil, South of Africa. The next slide. Ladies and gentlemen, the process of IV entry in the WTO trade agreement was quite lengthy, involving negotiation and lobbying between representatives of participating countries. There was opposition from many developing countries. WTO trade agreement relating to standardization of international intellectual property regulation. The WTO trade agreement is an agreement and recognition without exception of certain provision. This means that every country that agree must adopt and comply with all WTO provision. Actually, during the negotiation, developing country rejected the inclusion of IP issue in the WTO trade agreement. This situation reflected the awareness that strict implementation of the WTO trade would be detrimental to developing countries' access to intellectual property product and technology transfer. Represented by India, Brazil, Indonesia, and the other developing countries. And finally, it was approved after lengthy negotiation and pressure from developed countries. Various sources discussing the WTO state that the negotiation process was very exhausting for developing country representative. There might also have been certain promise made by developed country, and intellectual property was agreed to as a part of the WTO agreement related to trade, global trade. Yeah. Next slide. The inclusion of intellectual property issue in WTO is intended to integrated IP with global free trades. And IP is one of the most important part of the WTO agreement. And you know, the consequence is is strict regulation and international standardization. First, mandatory minimum standard. Yeah. With WTO member are required to comply with the protection of intellectual property. The three minimum standards are being implemented and efforts are being made to implement stronger standard in each country. The second, enforcement mechanism. IP is a part of the WTO agreement. If any dispute, the follow the WTO scheme through by a dispute settlement body in the WTO. What is the impact about that? Intellectual property is related to international trade. This is mean that as long as intellectual property is related to global trade, it must comply with WTO mechanism. I believe that almost all intellectual property products are related to the trade. So IP issues are then linked to international political economic. Next slide. Ladies and gentlemen, regarding trade, some implication for developing countries. First, technology access gap. Difficulty in accessing the latest technology. All new technology is protected by patent or other form of intellectual property. Access to new technology is difficult except through expensive licensing mechanism or purchasing technology product, creating an technology gap. The second, global competition. The challenge of competing in the global market with innovative product. For countries that are ready to compete, this situation has great potential to produce advanced technology and increase foreign exchange earning. And then potential for cooperation. Opportunities for technology transfer, research, collaboration, and local innovation. So far, for Indonesia, this cooperation mechanism have not significantly produced advanced technology. I don't know the other country. Focus on local need. The need to develop patent according to domestic need. This is a more realistic. For example, India focus on pharmaceutical, medicine, and information technology. I think Indonesia might be better suited to the concentrating on medicine based on traditional knowledge, geographical indication, and agricultural technology. Next slide. In fact, there has been an imbalance in the implementation of the TRIPS agreement globally. I have not at least three conditions. Patent dominated by developed country. This is clearly evident in WIPO annual publication. The second, pressure from developed country on developing country for the benefit of their own corporation, such as in the pharmaceutical industries. One example in Section 301 by the United States, which rank intellectual property violation and disease advantage U.S. trade, including priority, watchlist, blacklist, and monitoring the status of IP violating country. And that many patents in developed country originate from the traditional knowledge and genetic resources. It is no secret that traditional knowledge and genetic resources from developing countries are exploited and claimed through intellectual property regime. In the next slide, I would like to show you the data supporting my statement on this slide. Next slide. As you can see on this slide, this data show that global patents are indeed dominated by developed countries. These include Switzerland, Sweden, United States, the Republic of Korea, Singapore, United Kingdom, China, Germany, Japan, and other developed countries. Interestingly, the Republic of Korea at the 4th position, and China 10th position, as the developing countries have been able to compete and displace the dominance of other developed countries. This is an interesting study, and it is important for developing countries to adopt the good practices of the Republic of Korea and China. Next slide. And then next, the pressure pattern from developed country on developing country can be diplomatic pressure and economic sanction, and implementation trip plus and habit trip flexibility, and for technology transfer barriers. Developed countries are not actually serious about technology transfer. The pharmaceutical industry in developing countries is slowing down, and drug more expensive price. The next slide. Next slide. In this slide, next slide. Next. Okay. Many patterns sold from the traditional knowledge and genetic resources from developing country. In example, Japan, Shiseido Corporation patented flan 11 types from Indonesia. Patent claim cosmetic ingredient. Type of flan, example, turmeric, lempuyang. Lempuyang is ginger. Kenanga. Kenanga, I don't know in English. It is tropical flan in Indonesian. Yeah. Shiseido Corporation in Japan withdrawn after being protested by NGO from Indonesia and Indonesian government. The patent withdrawn from IV office in Japan. And the United States named 3 from India claim patent by W.R. Grace in United States, but the patent was revoked by the European Patent Office because it was deemed not to have any element of novelty. And 3, turmeric. Turmeric, the same of Shiseido case from Indonesia. The patent was revoked after the Indian Council of Scientific Research provided evidence of the ancient literature. And well-known case, basmati rice. Basmati rice patented in United States. But protest by India government NGO. Patent was restricted to only a few specific varieties. The name of basmati rice may not be used in the USA. Okay. I was time. Okay. Slide to, okay. Slide to 16. Okay. There are legal principles that don't actually originate from the concept of doctrine of intellectuality. The doctrine related to common prosperity or justice implementing of the intellectual property in the world. However, they are strongly related to application of intellectual property principle with a social dimension or concern for the public interest. This legal principle are ABS, access and benefit sharing, disclosure of origin, and prior informed consent. These three excellent concepts remain difficult to implementing in intellectual property law in the world because resistance from developed country. A stronger fight and concerted effort from developing country are needed to encourage developed country to implement this concept. Next slide. In this slide, I show you best practice in the China, South Korea, India, and then from Indonesia. I think the best practices based on the experience of Japan, China, the Republic of Korea, and India can be adopted by developing country, maybe Indonesia, Vietnam, Thailand, and other developing country. I believe that we cannot expect other countries to voluntarily provide what we need, what technology we need, especially advanced technology or patent. Therefore, there is no other way. Each country must strive to produce technology and patent independently, like China, like Korea, like Japan. And then that's bring me to the end of my presentation. I apologize for any mistake. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Yeah, thank you very much, Professor Chandra. Very insightful. And then, wait. Our final distinguished speaker today is Mrs. Hong Nung Pham from Hanoi Law University, Vietnam. And currently, she is also a PhD candidate at the University of Debrecen, Hungary. And I'd like to extend my gratitude to her because for us today, she is willing to be a very morning person, as we know that Indonesia and Hungary has 6 hour gap, so there is still like 4:30 a.m. So very early morning, just to attend this seminar. So thank you very much, Miss Hong Nung Pham. And her presentation today, AI-generated inventions and sustainable innovation, a comparative study of EU and Vietnamese patent law for the green transition, explore AI inventorship, the Dabus case, also green patents, and TRIPS flexibilities for developing countries. So Mrs. Nung, please, time is yours. You have 20 minutes.
Okay. Hello, everybody. Can you hear me and see me on the screen?
Yes, you're audible and visible.
Thank you. Will I will share my own slide, right?
Yeah. Could the committee please share slides of Miss Nung so that everybody can see the slides?
Okay.
Yeah, it's there. We can see your slides.
Okay, that's great.
Yeah, please.
Okay, can you still see it now, right? Okay, that's great. First of all, I would like to thank Emma and also the University of Bengkulu for my opportunity to present this presentation here today at the conference. It's true that it's 5:30 a.m. here, but I'm very awake right now. And I'm very ready to present my presentation. My name is Hong Nhung Pham. I'm currently a lecturer at Hanoi University in Vietnam, and I'm currently a PhD candidate at the University of Debrecen in Hungary. So today I will be sharing about my research about AI-generated works and sustainable innovation. I will be doing a little comparison between the law of the European Union, as long as my home country in Vietnam, about patent law in order to come up with a proposal for the law of Vietnam to deal with this novel phenomenon, as also to serve as a model for other developing countries to deal with this new technology issue. So today my presentation it will be about AI. So as you have known, since the new emergence of AI, especially generative AI, there has been many works which is created by the AI itself. And in the case that the new innovations which is created by AI, is the work patentable by patent law if the AI is the inventor? And also, can the AI be named as one of the inventors of the innovation? Especially in the new green innovation era, this is very important since AI now works as one of the fundamental tool to create new inventions to serve in the green transition period. So there will be two main parts in my presentation. The first part, we will talk about AI-generated works, patent ownership, and its implication with the law in the green transition. And the second part, we will talk about the EU's and Vietnam approaches to this issue, and we will come up with and I will propose a list of recommendation for Vietnam to deal with this new phenomenon. So first, let's go into the first part, which is about AI-generated works and patent ownership. So as Ms. Emma has addressed earlier, I will be talking about the Davis case. So if you haven't heard about this case yet, so the Davis case is actually one of the very famous case and one of the very first cases about AI-generated works and patent law. So this case was actually tried in more than 16 countries in the world. But today we will analyze the decision from the European Patent Office, which is the decision number J08 2020. So to talk briefly about what happened in this case, so there was a man, his name is Dr. Stephen Thaler. He invented an AI called Davis. And afterwards, Davis, without any humans interference, he invented a new invention by itself, which is a food container. And afterwards, Thaler he tried to file for registration, and he named Davis as the inventor of the food container. He named the AI. And afterwards, he tried to claim inventorship of this food container through the fact that through the employment doctrine, he said that Davis was his employee. So therefore, as an employer, he has the right to claim inventorship to the food container as well. So let's see what the EPO, what the European Patent Office say about this claim. So in this case, we have to deal with two fundamental questions. So the first question is that who can be named as the inventor? Can the AI be named as the inventor? And also, can the human claim inventorship through employment? And secondly, in the case that AI is an inventor, would the work be still patentable? So first, let's come to the first question, is that can AI be the inventor? So the European Patent Office say that basically in the decision, they say that under all of the law in the European Patent Convention and also all of their preparatory documents, they say that the law was made to name a human as an inventor. Therefore, an AI in this case, as a non-person, cannot be named as an inventor. And even though Thaler afterwards, he said that it's not fair not to name the AI as the inventor while it actually made the invention. They said that fairness in this case is also not a reason, is not enough to make them change the text of the law. So in this case, AI, it cannot be named as an inventor. So the second one is that can Dr. Stephen Thaler claim inventorship through the employment doctrine in this case? So they also say that according to Article 60, there are only two people who have the right to the patent, either the inventor or the successor. So in this case, he's not the inventor. So he tried to claim it by being the successor. And so through the through the decision, they said that in Article 81 and Article 60, they have to say that if the employee who invented the invention and the employer tried to claim it through the employment doctrine, they have to indicate the origin of the right to the in the application. But in this case, as Davis is an AI, would it be considered an employee? The decision also say that in this case, a machine had no legal personality. So in this case, Davis is neither an employee nor he has any legal personality to transfer the right to Dr. Thaler. So in this case, Dr. Stephen Thaler, in this case, he cannot also claim to be the owner of the patent since the AI is also not considered to be an employee. So if there is no inventor, if AI is not the inventor, and if the human is not the inventor, would the work be still patentable? So in the decision, they say that the invention can be patentable under Article 52, but it's still very limited. But however, they say that under the resolution number the resolution on IP right, they say that any technical creation generated by AI must also be protected under the IPR legal framework. So therefore, they are opening the door that these creation by AI can also be patentable. But however, in this case, even though they say that the how the invention was made play no role in the patent, and they said how the invention was made is irrelevant, but actually in this case, the the patent office actually told Dr. Stephen Thaler that he should try to file this patent again, but name himself as the inventor, so it can actually be patentable. So in this case, even though there may be a chance that it can be patentable in the future, but in this case, they didn't recognize the patentability for this food container also. So to compare this, the law of the EU with the law of Vietnam, which is the law on intellectual property, amended 2025, is very recent. We can see that it's mostly the same. In Vietnam, we follow an IP law which is almost identical to the EU. So in this case, the Vietnam approach is similar to the European Patent Office. So in this case, if it happened in Vietnam, the AI cannot also be the AI cannot be an inventor, and the human will not be able to claim inventorship, and also it will not be able to be patented under the law of Vietnam.
Uangnya tadi sudah Mama kasih kan?
So in this case, the takeaway is that Vietnam, as an developing countries, it even though there's no real cases happen in Vietnam, but it's still observing the law of other countries. And some scholars also propose a very forward-looking idea, is that they say that because if the invention is not patented, it may take away the ability that the company will disclose their technology. So they say that there will be a forward-looking idea is that they can recognize AI as an inventor, while still attribute all the ownership and legal rights to the human or a company which owns it. So in this case, we still can have the disclosure for technology while still having a human inventor. However, this is still just an idea, and it hasn't really taken place in reality yet. So in this case, if the work generated by AI is not patentable, if there's no human inventor, in the green transition era, which all of these inventions are very important, can there be an exception to AI generated works and patentability in this? What can it be an exception only for green related inventions in this case? And if there is an exception, it may create the ability of either patent flooding, or maybe it will raise the patent tickets very, very high. So if there is this possibility, how to deal with the possible consequences of this as well. So this actually create a debate between patent and ethical, which is if we follow the routes that we allows an exception to encourage patentability, it will strengthen innovation and it will avoid companies from not disclosing their technology. But however, on the other hand, that if we allow this exception, all of the big companies, they will be the ones which will benefit the most. They may really they may create monopolies on the AI-generated green innovations market, which can really increase the cost of innovations and also create very high entry barriers for all of the new innovations to the green market as well. So let's see how the EU and Vietnam is dealing with this question. So in the EU, the EU is basically, as a very big holder of the large share of the global green technology, they are trying to fasten up the time to market time for green innovations. And they say that IP law is actually a very important part to encourage more green patents, which was set in the European Commission's Intellectual Property Action Plan in 2022. But however, in order to encourage new innovations, they also have to keep their traditional doctrine, which is to maintain a very human-centric patent system. And at the same time, they have to encourage new innovation as well. So there's a scale that the European Patent Office, they have to balance with this too, how to maintain their old original value and still encourage new innovations. So the approach of the EU to this issue is that they're very cautious. They are still sticking with the traditional doctrine, and they observe a lot of the new developments. And they don't come up with new law or new guidelines about this. However, they acknowledge that there is a lack of rules on AI inventorship, and they try to encourage green innovation by the way of fundings and collaborative research. So in this case, if the EU's approach is cautious and careful, it's very likely that they will reject the exception approach, because it may very likely go against their traditional doctrines, which the European Union is they emphasize the traditional doctrines a lot. And on the other hand, from the approach of Vietnam, currently, Vietnam hasn't really treated this issue very differently, even though recently there has been a lot of researches and a lot of conferences on the issue of green innovation as well. But there hasn't been any substantial new step in the law of green innovation. But however, Vietnam is very open to new AI related matters. As you can see, that Vietnam is actually, we have our own AI law, which was established at the end of 2025, and also the new amendments of IP law, which was also established at the end of 2025 to include some articles on artificial intelligence, even though it hasn't really addressed patent. But as a trend that we are opening our law for new technology, there is a chance that we may address this issue differently from the European Union. So, in the case that we want to allow the exception, in this case, we can try, like in my opinion, we can try using the flexibilities from TRIPS agreement to, like, we can open it up, but in very little by little, not all at the same time, but we can use small measures, such as first, maybe delay and limit of scope of AI patentability. And secondly, we can try using compulsory licensing and also adopt disclosure norms for AI-assisted invention instead of opening AI-generated works patentability right away. And we can see that we can see a little table as I want to compare about the approaches of the EU and Vietnam. So different from Vietnam, EU is, even though they're sticking to their traditional values, they are still very actively studying this matter because there are real cases happening in their area. And Vietnam, even though we're quite active and we're open to new law about AI, but we are still a little bit on the more passive side because we have to wait. We're still observing more developed countries and how they are dealing with this before we come up with our own solution to this issue, because we haven't had any real cases yet. So in my opinion, I think the current approach of Vietnam, and also as a model for other developing countries, that this is actually a quite understandable and suitable solution, because it's not a very because to prevent possible consequences like patent flooding, thickets, or like the decrease in the quality of patents, we have to take this very seriously and take very careful steps towards the new AI-generated works, and especially for green innovation, because green innovation right now in Vietnam is very important. We are trying very hard to develop our quality of the environment, starting from air and then to water and then other parts of the country as well. So this is so this is the end of my presentation. This is a quick summary recap of the whole presentation about inventorship, patentability, policy approach for the green innovation. And yes, this is it. So thank you for listening.
Yeah, thank you, Miss Nung. Applause for Miss Nung, please. All right. Before we come to our Q&A session, or especially for Professor Nazura Achanki and Miss Nung, that our faculty now is developing a program that allow our students to like choose or so the name of the program is like swap student or student exchange, but this is for bachelor degree program. But the master program also plan to develop the program to have also like allowing student who interested in doing research on like comparing laws to uh, other states. Then we hope the dean asks for your willings to like be the supervisors of the students, to like guide them to run their research. And also in the next coming year, we also plan to do like research collaboration and joint publication also with the lecturers from your sites, and we hope that it can happen soon. So every speaker has already delivered their participants. Now we move to the but in asking the question, please kindly mention your name and also institutional affiliation and to which speaker your question is addressed. Ya, jadi tolong sebutkan nama, instansinya, kemudian ke speaker yang mana pertanyaannya ditujukan. And to make our discussion efficient, we have lots of time here, an hour. I will first take 3 questions, 3 pertanyaan terlebih dahulu. And I need 1 or 2 committee to help me, like to choose which one to choose. Yeah, because there are many people here and there'll be many people who's gonna ask questions. So please help me in choosing or deciding which one. Maybe per jalur or cewek cowok, something like that. Yeah, maybe you can stand in the middle of them. It's like to make you easier to decide which one. That's gonna be the yeah penanyanya. Let's start our first question. So who wants to ask questions, please? Yeah, there will be door prizes. Yeah, there will be door prizes for the best 6 questions. So please ask. Yeah. Akan ada door prize, begitu kan panitia? Ada door prize untuk 6 penanya. Disilakan. Silakan.
Cek. Thank you for moderator Bu Emma Septaria. I want to question for Miss Nuramal Tanishro and Prof Nazura binti Abdul Manaf. My question in English and in Indonesia. How can the concept of ownership in intellectual property law be reconstructed to accommodate AI-generated works without undermining the principle of human authorship? Example of I'm creating the logo company in AI and how it is owned in the modern legal perspective in Thailand or Malaysia. And finally, if you would like to answer using a combination your native language and English. Dalam bahasa Indonesianya, bagaimana konsep kepemilikan dalam hukum kekayaan intelektual dapat direkonstruksikan untuk mengakomodasi karya yang dihasilkan oleh kecerdasan buatan tanpa menghilangkan prinsip human authorship. Contoh, kalau kita membuat logo perusahaan menggunakan AI,
Okay. Directly, we collect the question first, then let's just answer them one by one. Second question. Question addressed to Achanki and Professor Nazura. It is from Ramadoni, the students of master program, and he questions about actually the ownership. Yeah, the ownership. How to reconstruct the regulation related to something created by AI without undermining the work of the human itself. Yeah. So could you please answer first?
Yes, thank you. Good question. Yeah, of course, like for AI's work, it might recognize as program computer in some house. But I will answer for both questions together. For some work like literature, like if you concern, because all of you, the master student. Yes, for all of you like have to get some information from AI sometime, right? So that why it's concerned. It usually content of the copyright material, so that's why I ask you like, to you supposed to rewrite it again, or even we have to check it again if the ownership one it we got the exemption. Maybe it's the same as my country. Like for any copyright material, you can use for education purpose, right? But even you can use for education purpose, you're supposed to get the reference as well, or you have to rewrite it again to get your new work, but you have to put the name on the reference as well. It's our protection. I always teach my student as well. Like when you get artwork, like for literature review, you cannot get the new idea, cannot get by own theory. So that's why you have to get for art, but you have to write a new one and get it for, reference as well. Yeah, for in nowadays, the new work that contained by AI generation still not accepted in Thai. Yeah, so that's why that's still undeveloped from AI. We still use, we accept to use AI as well, but the work that created that content almost like for AI generators, it is still not accepted in Thai. Yes. Thank you.
Prof. Nazura, could you please respond to Ramadoni question? You are still mute, Prof.
Okay. Okay. Thank you very much for the questions. Okay. Right. The questions are, sorry, because just now I was actually the audio was controlled by the admin. That's why I cannot answer. Now you can hear me, right?
Yes, audible.
All right. Thank you. Thank you. Okay. Responding to the questions by Ramadhani just now, yeah. Right. If you are talking about to recognize the AI work, meaning that machine created work, but at the same time, you want to make sure that the position of human being, because as I mentioned in my talk just now, we don't want most of the law in the world, why they actually still retain it must be authored or owned by the human, because otherwise in the future human is no longer relevant. Yeah, right. So now the answer to your question is the first one, of course, you follow whatever that we have now. I think in Thailand, in Malaysia, in Indonesia, in most of the countries in the world, in Europe, in US, most of the countries, they have provisions saying that be it the non-related work, non-AI related work or AI related work, it must involve human being. Yeah, how minimum it is. Yeah. Okay, so meaning that you like it or not, to recognize AI work in copyright. Yeah, in copyright, then it must involve human being. Yeah, but of course, with the advancement of the advancement of the technology, I think perhaps in very, very near future, I think perhaps now also, you can just push a button and then without even prompt, for example, based on the training that the AI had. So he can actually create it because when you talk about AI, it can involve machine to machine learning without human intervention. Yeah. But then when you talk about copyright, it still needs human being. Another way of giving recognition to machine without human is through contract. So meaning that, for example, contractual agreement, you say that although it has no protection under the copyright law in this particular jurisdiction, but you are bound under the contract of the law of that particular country, for example. But the difference between the copyright and contract protection is copyright, it's just like you against the world, meaning that the moment you fulfill requirement as mentioned by Ms. Narumo, eligibility of copyright just now, once you eligible for copyright, then you get protection and you can, protect, and anyone infringe your work can be taken action under the law. But for contractual agreement, it just between the person that actually within the contractual atmosphere. So meaning that if you are in parties to the contract, then you bound to the contract. Another ways of doing it, I think now EU and the EU Act, EU AI Act, what they do is not under copyright, it's not under contract, but they require you to insert, to label the work as AI generated work. So that is also saying that you give some recognition to AI, even without human being involved in the making of the work. So I hope that I answer your questions, Ramadhani. Yeah? Thank you.
Yeah. Thank you, Prof. Nazura. Should I translate? Sudah ya, cukup ya. 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 So
Saya pun boleh berbahasa Melayu sebenarnya. Kalau mahu saya bercerita sendiri dalam bahasa Melayu, kalau difahami lah ya, bukan bahasa Indonesia ya. Sulawesi mungkin saya nampak rupa saya di situ. Baik, begini, mengikut Undang-Undang Hak Cipta, ya, mengikut Undang-Undang Hak Cipta, mesti ataupun IP lah mesti ada pemunya, pemilik ataupun pencipta, author, ya. Kalau tidak ada, tidak dalam rangkuman ataupun perlindungan yang diberi oleh Akta Hak Cipta. Ya, okey, itu berlaku di seluruh dunia. Walau bagaimanapun, sekiranya kita dapati bahawa ini semuanya macam Zaria, kes Zaria tadi, komik itu lukisannya dilukis oleh AI, maka tidak diberi pengiktirafan di bawah copyright. Bagaimana untuk mendapat pengiktirafan begitu? Menurut undang-undang, salah satu daripada alternatifnya adalah menurut akta kontrak ataupun menurut perjanjian ataupun kontrak yang biasanya akan dilindungi di bawah kita panggil sebagai undang-undang perundangan kontrak kan, kontrak aksesnya di Indonesia pun dipanggil kontrak ya. Jadi di situ apa perbedaannya ialah kalau di bawah akta kontrak yang terlibat hanyalah kedua-dua pihak atau beberapa pihak yang terlibat dalam kontrak itu sahaja. Tetapi di bawah akta hak cipta semua terlibat. Maknanya kalau dilindungi di bawah akta hak cipta, semua orang di dunia ataupun kurangnya dalam teritori tertentu. Ingat sebab hak cipta hanya dilindungi dalam teritori ataupun dipanggil apa ya, negara-negara tertentu sahaja. Dia tidak keluar daripada negara kita sebab ini bukan undang-undang yang terpakai dalam antarabangsa, dia terpakai secara domestik. Saya harap Ramadhani faham apa yang saya cuba sampaikan lah. Mungkin Dr. Emma mungkin boleh memberi
iya,
penerangan lagi.
sudah paham katanya Prof. Terima kasih
Okay,
atas
Alhamdulillah.
penjelasannya. Ya, kemudian Ramadhani salah satu cara lain tadi adalah memberikan label bahwa
Ya, ya.
kreasi tersebut adalah buatan AI atau AI generated work. Begitu. Nah, terima kasih Prof. Selanjutnya, next is a question from Rizky. addressed to Achanki, still asking whether AI can be the original owner and that can AI be the inventor? Yeah.
Yes, AI can be original or I say no. In nowadays, like even any intellectual property, it's supposed to the initial come from human. So even I ask you like when you type in Google or something, create new song. You know, even in TikTok, it's supposed to be the same in my country, right? So nowadays, in TikTok usually have like the song that come from AI. Yeah, if it's come from the pure AI, it cannot protect it as a copyright. Yeah, in nowadays, yes.
Thank you. Yeah. Rizky, how? Mana tadi menanyanya Rizky? Rizky first. Sudah ya? Sudah? Oke. Okay. So, penanya terakhir, the last question di termin pertama from Dava. It is addressed to you again, Professor Nazura. Dava, where is Dava? Could you just repeat your question in bahasa because Prof Nazura will understand.
Ya, ada 2 pertanyaan, Prof. Nazura. Pertama, kenapa anggota WTO itu wajib mengikuti standar minimum hak kekayaan intelektual? Lalu pertanyaan kedua adalah, apa saja standar minimum yang diwajibkan dalam TRIPS? Sekian.
Baik, ya Prof Nazura. Pertama, mengapa semua anggota WTO harus mengikuti standar minimum dari PI? Kemudian apakah yang termaksud dalam standar minimum tersebut?
Baik. Saya rasa ya itu sebagai satu mekanisme antarabangsa, ya mekanisme undang-undang antarabangsa, sekiranya ya kenapa kita perlu ada satu legal instrument ataupun instrumen undang-undang di peringkat antarabangsa ya. Salah satu sebabnya adalah untuk memastikan semua negara dilindungi ataupun juga melindungi kalau kita berceritakan berkaitan dengan harta keintelektualan, melindungi perkara yang sama. Ya, kalau tidak nanti ada negara yang kata kami tak lindung ini. Tetapi hasil karyanya dilindungi pula. Contohnya mungkin dilindungi di Indonesia tetapi tidak dilindungi di Malaysia. Kalau tidak ada standard tertentu. Ya, oleh yang demikian perlu ahli-ahli perlu ada standard. Biasanya mereka akan beri minimum sehingga macam Malaysia dulu tak silap saya untuk TRIPS WTO adalah 6 tahun dan kami berjayalah mengikut tempoh masa yang diberikan ya. Maknanya itu adalah antara sebab lah, mungkin ada sebab-sebab yang lain dari segi international law-nya, tetapi dari segi pemahaman secara bagi saya logik aja, kalau tidak ada minimum standard, bagaimana sesebuah negara itu tahu apa yang mereka perlu, what are the do's and the don'ts yang mereka boleh lakukan contohnya ya. Itu pertama. Yang kedua soalannya, apakah dia minimum standard di bawah TRIPS ya? Biasanya ya minimum standard itu sangat basic. Contohnya dia perlu ada akta hak cipta, perlu ada patent untuk melindungi patent, perlu ada contohnya apa nama tu industrial design, geographical indication, perlu ada kalau dalam TRIPS tu antaranya lah copyright dan related rights ya, ada trademark, geographical indication, industrial design, patents, layout, design of integrated circuit, undisclosed information, SHS trade secret dan juga anti-competitive licensing. Itu antara perkara minimum yang perlu ada. Tetapi adakah perkara undang-undang itu perlu dalam bentuk akta? Tidak semestinya. Ya, contohnya kalau kita saya bagi contoh lah, protection of undisclosed information. Undisclosed information ni lebih kepada kerahsiaan, secrecy kan, secret kerahsiaan. Macam di Malaysia kami tidak ada akta kerahsiaan. Saya rasa Indonesia baru ada akta kerahsiaan Malaysia belum ada lagi sebab apa, walaupun kita tidak ada undang-undang khusus tetapi kita ada undang-undang yang telah guna pakai lama dahulu yang kita panggil sebagai common law legislation. So kita menggunakan common law bagi memberi perlindungan kepada maklumat-maklumat rahsia. Kalau maklumat-maklumat rahsia ni banyak, tetapi kalau kita menceritakan atau membahaskan dari sudut undang-undang harta intelektual, makanya contohnya resepi ya, ataupun maklumat-maklumat pelanggan dan sebagainya, resepi dalam McDonald, dalam KFC, Coca-Cola dan sebagainya, sebenarnya dilindungi di bawah kerahsiaan, dan kerahsiaan itu biasanya akan disusuli atau disokong dengan apa yang kita panggil sebagai perjanjian kerahsiaan. Saya harap saya menjawab soalan yang diberi oleh siapa, Muhammad tadi ya.
Dafa, Prof.
Ya.
Dafa, ya. Thank you very much,
baik.
Prof. Ya.
Okay. You're
Dafa,
welcome.
is it
You're very much
clear?
welcome.
Clear ya? Yeah. Thank you, Prof. Nazura. Now I will open the second termin. And as the time is getting near to 12, I'm going to open only 2 questions. So please again, come to waktu time. Ya. Ini kayaknya bapaknya pinter deh, jadi biar nggak nanya. Sebenarnya off the microphone. Ya, di situ silakan Ibu Cita, pilih yang mana? Ya, itu. Iya.
Tiga apa dua?
Dua. Waktunya nggak cukup.
Yang cewek aja.
Lihat kalau masih ada waktu nanti kita tambah satu lagi ya. Sekarang 2 dulu. Silakan.
Baiklah, Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
I'm from University of Islamic Fatmawati Bengkulu. My name is Etrimike. I'm a lecturer too. Thank you to Miss Emma and Dean of Faculty of Law, Dr. Yamani. Okay, I want to ask maybe to Prof. Chandra and from Vietnam? Nung. Miss Nung. Okay, karena because they don't have any question, I want to try to ask question. Okay, I want to ask about can you give some of advice to our country Indonesia and because about the law on IP, because our country don't have any they have a law IP in 2025, and our and Indonesia just talked in 2016 about patent. Yes, it's too old. They have and so I just want to you give us some advice to our government how to supposed to do about this circumstance, because AI is so much increasing at that time, and but our country Indonesia don't have any regulations about it. It's a worry about it. Thank you.
Thank you, Ibu Etrimike. So and for Mr. Nung, Miss Nung? Oh, so the same question. Yeah, asking that. Okay, but the question is for Prof. Chandra. Okay, our last question. Yeah.
Thank you. Allow me to introduce myself. My name is Shaftiara Alisa from the Faculty of Law, Universitas of Bengkulu. I would like to direct my question to Ms. Narumal. So my question is, in your presentation earlier, you mentioned that AI system require large amount of data for training, including material that may be protected by copyright. If that data include traditional knowledge or data belonging in indigenous communities, could this be categorized as a new from a digital biopiracy? And in your opinion, are they current intellectual property? And my second question is, and in your opinion, are the current intellectual property laws in ASEAN countries prepared to address this threat? Thank you.
Okay, Achan Kiso. Yeah, thank you. So I only will open two questions. If we still have time, then we will proceed to another last question. So the question from Ibu Etrimike addressed Prof. Chandra. Prof. Chandra, are you still there? So Etrimike asked for the advice for Indonesian government act of patent because it's stuck in 2016. So
Yeah.
it's mature enough, yeah, to be an act while the development of any other countries being there. So could you please give some advice to our government? Silakan Prof. Chandra.
Baik, thank you Ibu Etri Mika, lecture from
Winfast.
Mawati Bengkulu, ya, Winpas. I have question. Should Indonesia include AI in IV law? The answer is yes, of course. And question, how should it be regulated? Yeah, how should it be regulated? We can see once it's become developing globally. Now, this is a hot topic in international law today. To my knowledge, there are differences in approach between courts in the United States and China. In United States, the principle of human authorship, AI, not human. In this case, in the case Taylor versus Perlmutter in March 2025, the U.S. Courts of Appeal upheld a provision ruling that copyright requires a human actor. Creativity machine was denied. The court stated that despite technology advancement, copyright law is designed to protect human creativity, not machine creativity in the U.S. Courts. In China, China is a more flexible approach. Yeah? Unlike the U.S. courts, Chinese courts are beginning to recognize that the use of AI with detailed instruction can constitute intellectual property. You can see and read the case Li versus Liu. Li versus Liu in the Beijing Internet Court in late 2023. Yeah. The courts ruled that image generated through stable diffusion could be copyright. Difference with US. The reasoning was that the plaintiff provided very specific prompt. Jadi very specific prompt. Instruction is unique instruction. Set parameter and choose the final product. This was considered a form of intellectual investment and a human aesthetic expression. In Indonesia, we can see about in the China codes and US codes. But to my knowledge, currently no country has implemented AI in the IV law in each other. Indonesia must be waiting, wait and see, wait and see about developing globally in the world. I think it's my answer. Thank you, Ibu Emma.
Thank you, Prof. Chandra. So, yeah, Bu Etrimika. That's the answer from Prof. Chandra. And we proceed to Safira question addressed to Achanki, asking about data training on AI and your opinion whether ASEAN countries' law regulation already prepared to face this kind of issue.
Yeah, thank you. Yeah, it's very good one. You know, like for the traditional issue or even indigenous issue, it's not copyright material. So it's mean like even for, it used to be copyright material, you know, when they expire like for whole life and add on 50 to be succession. After that, it will be free. It will be free. It's mean like anyone can apply to your work, but it still cannot get the new copyright work if you include like many material that come from indigenous or even the free one or the traditional one. Yeah. And for like the challenging for ASEAN, as I told you, right, there's only one country that prepare like for in Southeast Asia is still no, but in China, even in South Korea, is already prepared. And I think like in the few years further, many countries will prepare to accept that. You know, like AI is just play like very important roles in nowadays. Even in the university, like for educational purpose, like for if you still free to use, it's gonna be have some effect as well. Yeah, thank you.
Yeah. Yeah. How, Safira? Yeah. So it's possible for one last question, please. One last question, yeah.
Cek. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Let me introduce myself. My name is Rivaldo Liansa. I'm from the master program at Bengkulu University. I have two quick questions for you. Mrs. Narumal Tanisro. As a student, how can we use AI ethically and responsibly? And the second question is, how can an AI be a good innovation for a student? Thank you.
All right. You mean like you would like to use AIs for your education, right? Actually, I'm not sure like we get the free version and to paid version, right? Actually, in my country, it's just for my university, they paid like for one AI model for us to help us to use. As I told you, right? Because actually, you should start writing by yourself. It's the first thing that you have to know. Even you search any information, right? You have to rewrite to like the new work. Yeah, you got a new work and then you back to AI again. You back just let them to check your spelling, you know, check your grammar, even to check like for it academic enough for that. You know, you have to do it in every single paragraph or something because normally we also do that because we're afraid of to get some infringement or something. Yeah, I think like when you would like to get a new work, you should start from yourself first. Even the idea, some idea does come from AI. You know, like same as my student that I told you, like they ask AI like, what is the interesting legal problem is nowadays? Then you got it. AI will ask you more. Would you like me to present you a, you know, like some concept paper or something? You can use that to be your guideline. but you're supposed not to that to be your main one. Yeah, supposed to be like that.
So 6 questions. Okay. Um, so let's give applause to our four speakers. Yeah. Yeah. So we come to the end of our seminar. So distinguished speakers and participants, before we close, allow me to briefly make a brief synthesize today's discussion. So today's session has shown us that the future of intellectual property law lies in the intersection of technology, justice, sustainability, indigenous knowledge, and public welfare. And also, we have explored how AI challenges the traditional human-centered structure of authorship and also inventorship and ownership, and how data and deepfake issues require new regulatory responses, how public interest doctrine and TRIPS flexibilities remain crucial for developing countries, and how green patents raise important questions of fair access and global responsibility. So taken together, today's session reminds us that international intellectual property law must evolve not only to protect innovation, but also to ensure equity, common prosperity, and welfare of the humanity. So on behalf of the organizing committee, I would like to express my sincere appreciation to all of distinguished speakers, Achan Ki, Professor Nazura, Prof. Chandra, and also Ms. Nung to become our speaker today, and all of the participants for this intellectual, enriching, and globally relevant discussions. And I personally hopes that this seminar will not stop here. Then there will be many ideas that come up from these meetings, right? And many collaboration, academically or non-academically, that will emerge after this seminar. So thank you very much for your presence and contribution. I wish you all a wonderful day and fruitful future collaboration. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. And I'm gonna give the microphone back to our MC, Ibu Zia. Back to you.
Thank you
So,
very much
shall we?
to our moderator and all distinguished speakers for the insightful discussions. And also thank you to all participants, both on-site and online, for your active participation. And now, ladies and gentlemen, we will now proceed to the presentation of certificate of appreciation to our distinguished speakers. May I kindly invite the committee to present the certificates. And for speakers joining us online, the certificates will be delivered accordingly by respective emails. Thank you. Committee. Yes. Ashanki, please. And the committee. Distribution of door prize for our selected participants who have actively engaged during the discussion session. There will be 6 door prize for selected participants in the hall. And for this joining us virtually, don't worry, we truly appreciate your participation as well. Your reward is our sincere appreciation and virtual applause. And to 6 selected participants, please take Pak Dekan, ya. Pak Dekan, Bu Emma dan juga Ibu Ike mohon ke depan dan juga narasumber and Acanki, please. Kalau Oke, udah udah kan? Udah. Please be seated. Ladies and gentlemen, we will now proceed to a photo session for the master's degree students of the class of 2024 who have organized this seminar. May I kindly invite all master's students of the class of 2024 to come forward. For participants who would like to take a photo with Achanki, you may kindly do so after this seminar. Bagi yang ingin berfoto sama Achanki nanti setelah seminar,